Good afternoon, good afternoon, good afternoon. It's Thursday. It's October 30th. It is spooky season and we are going to court. I think the only one spooked by this hearing is probably former Trooper Proctor because, again, though he won't be in court, he is the subject of the conversation. So, if you have the Law Nerd app, then you would know we had a little bit of a time change today to accommodate court. If you don't have the Law Nerd app and don't want to miss a moment, now is the time. Download it for free. It's not spooky. It's only spooky if you miss court. I promise. iOS and Android. All right. Replay crew. Everything's linked down below if you want to jump to certain times because we are going to go to live court, and that includes, bumps and wiggles and dead time and all of the rest of the things. So we are going to just roll with it because it's an afternoon court hearing. And we're going to roll the intro. We're going to go to court. I'm going to give you a quick summary for those of you tuning in. Like, what case are we talking about? Well, multiple cases, but it's still Proctor problems. It's still Proctor problems. Let's go to court. You guys ready? I'm ready. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. For a quick summary of what we're doing, we are going to court for a group of cases that is still dealing with discovery. Oftentimes, the filings are in the Miles King case, which is a homicide case pending trial. The defendant is now out of custody due to extensive discovery delays because of Lally and Proctor. And then there are other cases connected to this, including the Brian Walsh case that was supposed to start trial this month, October 2025, and has been pushed. I think it will probably get pushed again, but we will see. And the issue that they are dealing with is kind of twofold. One, they are dealing with state Proctor discovery. The Commonwealth of Massachusetts grabbed Proctor's new phone and his lawyer was like, he changed his phone. So there's not much there. And he, everything auto deletes on the phone like every 30 days. So good luck, everybody. And then the prosecution was like, okay. And then they downloaded the phone and it went all the way back to 2013 because of the iCloud. So they found, instead of, there's nothing there, they found hundreds of thousands of texts and photos and videos and emails and group chats and more. Oh my. And so the prosecution is now digging through all of that to figure out what is discoverable in any of these 5 cases and possibly more. So there is the Commonwealth Proctor discovery from the personal phone. Then there is the federal discovery from the work phone and possibly the personal phone. It's still kind of unclear, but the federal discovery is what was turned over in the Karen Reed case. Remember, that federal discovery was turned over under protective order from the feds to the Commonwealth. And the Commonwealth was told, hey, you can have this for the Karen Reed case, but you can't tell anyone else about it and can't give it to anybody else. It is under a protective order. But Karen Reed's defense attorneys get it. The prosecutors for this case get it. Nobody else. You can't give it to anybody else. Don't talk about it. We don't talk about Bruno. It doesn't exist. Then, because the case was televised, all the defense attorneys went, excuse me, it seems like there's probably more. Can we need that. And the Commonwealth is like, excuse me, there's probably discoverable information that we need to give to these defense attorneys, but the federal protective order says we're not allowed to give it to you. But we know it exists. So we're telling you there's discovery that you need, but that we can't give it to you. And they have been back and forth on that at the federal level. And last time we were in court for these cases, the prosecution said to the court, hey, so the feds have allowed us to turn over the discovery that we asked for. So not all of it? Well, the discovery that we asked for. Okay, so not all of it. Well, the discovery that we asked for. Okay, so not all of it? And then the defense was like, well, how can we know if there's not more that we might need? If there's more that, what? And the prosecution said, don't worry, we got a log of all the discovery. So if you think there's more that you need, you can let us know. And oh, by the way, The feds told us under that federal protective order that we needed to either destroy the discovery that we have in our possession or give it back to them by October 31st. Okay? And the court said, shit, we're going to need another hearing date. So today is that other hearing date. Because the court's like, what are we doing? I want to be clear, though. The federal protective order that covers the Commonwealth's behavior with that discovery does not cover what the feds have. So it's not as if the feds are going to be getting rid of things. The feds gave it to the state and said, this isn't yours. You can't keep it forever. And so this is not that it's going to be poof gone forever. It might make it more legally complicated for the defense to get, but it is not going to be gone off of everywhere. The feds said this belongs to us. You can have it for a little bit. You need to give it back. This is the date you need to give it back by. I want to see if the court is going to say, give it to me then. I'll fight with the federal court. Give it to me then. Give it to me then. Then you have filled your obligation. I can fight with the federal judge. The defense doesn't have to worry that this is all going to get destroyed and they're never going to be able to get it again. Give it to me. I'm waiting to see if the judge does that. So we'll see. But the destroy or return order does not mean the feds are getting rid of it. So it means that the Commonwealth can't still have it in possession. So I think there's a lot of confusion about that it's going to be gone forever, but it's not going to be gone forever. It just might be harder to get because the feds still have it. Hopefully that makes sense. So we're going to go to court. We're going to see. I would hate to be these defense attorneys. I really would. I would be so frustrated. I would be so incredibly frustrated. I'm frustrated. You're frustration. We're all frustration. We are frustration. And imagine if the Karen Read case hadn't been so public. What would the defense attorneys know about what might be there? Or would they ever get it? When I say that I think cameras in the courtroom are a good idea, it is for so many reasons. I hate that the public sometimes, not the law nerds, but some seek to intercede in these cases, and there sometimes is nonsense and fuckery. But overall, there is a lot of good that comes from it because the defense attorneys are aware of these things because it was so public. I think that the prosecution would still have to tell them, hey, by the way, there's discovery, but the feds haven't, we can't give it to you. But I don't know if I trust that to happen in this case. So I'm glad that it's getting aired out for everyone to see, and we're continuing to see it aired out. Are you guys ready to go to court? I want to say, go to Logan, grab a Dunkies, and let's get on EDB Air, but we're flying into Logan, so it doesn't make sense to just take a drive around the tarmac. So head to B&A, grab a Starbucks. We're going to get to Logan. We're going to grab a Dunkies. We're going to go to Massachusetts. Let's go to court. Hopefully we've given ourselves a little bit of zoom room. This is probably going to be a short hearing though, so I'm going to save questions and super chats and stuff till the end as best I can. Let's go. It's time for court. It's time for court. It's time for court. Law nerds, hear ye, hear ye, hear ye. It's time for court. It's time for court. Hopefully the sound isn't absolute abysmal. Just terrible. Fingers crossed. Hopefully you can hear it. Ish. So, optimistic. Sounds like the judge is coming out. Make sure your phones are silenced. Law nerds, you don't have to. I'm not telling you what to do. That's what they're saying in court because it's a little hard to hear. Sounds like they just gained up the mics there in court. I saw some of you asking if Proctor's in court. I wouldn't suspect Proctor's in court. I suspect if Proctor has retained new counsel would be watching. If not, then, wow, that's riveting. It is. We do have the OnlyFan back, though. I would also imagine that if Proctor is not retained new counsel, he's probably watching or attending via Zoom, because you can attend via Zoom. He's a related party here. They're calling the 5 cases, including the Walsh case, even though the Walsh case is technically stayed, but they are calling the 5 cases together because this discovery issue spans these 5 cases, and it might span more. I know that's not what anyone wants to hear, but that's just the reality of the situation as I see it. Hopefully this will gain up as the parties start speaking. That's a different case. This is a non-evidentiary motion to suppress on a non-related case. Hold on. We're going to zoom until they're done. This is why I give myself zoom room. There we go. Where are the defense attorneys I recognize? Goodbye, motion to suppress. This will give me a minute to, let me see if I can gain up the volume a little bit. As they call these cases. The court does have other cases on calendar. I know it's shocking. That's better. There we go. Zoom room. Zoom room is always needed. Okay, what I said before about them calling all the 5 cases that are associated, they're doing that now. So they called all the cases, one DA representing all these cases for these hearings. Brian Walsh's attorney is appearing via Zoom, and the other attorneys all seem to be in person. A number of the defendants are out of custody, present in court. Thank you, Rosemary, for being so easy to hear. We stan. It's just, there is one attorney in this courtroom we can hear.
Good afternoon, Your Honor. Attorney Corey Madera on behalf of the Attorney whose presence is waiting today. Filling in for my colleague, Attorney.
Can you just spell your last name for me?
Madera, M-A-D-E-R-A.
Okay.
Judge, Attorney Joseph Krosky Jr. on behalf of Giovanni De Los Santos.
Hey, Joseph, we can hear you too. Fantastic. Thank you. I love it when I can hear the attorneys.
You are very faint to hear, Mr. Tipton, and remotely, but I heard that you're representing Mr. Walsh.
Mr. Tipton is calling in from another solar system, apparently, via Zoom. He's like, I'm representing Mr. Walsh. Can't hear him at all. Would Zoom court be Zoom court without some horrible echo because somebody's not using headphones? Sure would. What if any of the CLE companies would like to just hire me? I will do CLEs on how to appear on Zoom and not end up in this circumstance. Because, good Lord. Someone forgot to mute.
Okay, gentlemen, you can be seated.
Also difficult. I'm just trying to find my notes on this case.
Okay, we're here for updates.
Yeah, we are.
Your Honor, from the Commonwealth's perspective, nothing has changed since last.
I'm going to repeat a little bit, but from the Commonwealth's perspective, nothing has changed. They're really here for the defense attorneys to lodge their objections, complaints, their issues with what's being turned over. Remember, the Commonwealth said, we're just turning over what we asked for. And the defense is like, ayo, we worry that there's more. I think those worries are founded.
We believe that we have complied with Rule 14 in our obligations, and we intend to comply with Judge Casper's order and return and destroy materials tomorrow morning.
The prosecution said, we intend to turn over what we're ordered and return and destroy everything else tomorrow morning.
I have my phone out, and I apologize for the court, but I know that Mr. Tipton filed a motion at around 12:30. I don't have it in hard copy, so I'm going to have to review it on my phone. I don't have any other pleadings from.
I'm going to try to gain this up one more time. The prosecutor is saying that Tipton filed a motion today. She doesn't have the paper copy of it, just digital. So it is on the phone. And so she has her phone in court so she can look at the motion on her phone. Hopefully this gain will help. Fingers crossed.
I'll give you a hard copy. I'll give you my copy.
It's a little bit better. The court did say, I'll give you my copy.
Oh, great, thank you.
You have it. Okay. Should we put this on for a second call?
No.
No, I think that I prefer to, it's somewhat bare bones, the motion, so I think that at this stage, Mr. Tipton ought to argue first.
Okay. All right.
Tipton's on Zoom. He's the attorney for Brian Walsh.
Is there any other issues with respect to Mr. King, Ms. Chanchillo, Mr. Johnson, Mr. Del Santos?
May I, Your Honor?
You may.
On behalf of Mr. King and Mr. Johnson, I have had a number of conversations with Commonwealth trying to work out what's remaining out of the federal materials before they are destroyed tomorrow. It was my initial position that if the Commonwealth, if there are certain grand jury minutes that relate to the Karen Reed case that we're looking for, that are both in the custody of the federal government and in the custody of the Norfolk County District Attorney's Office, as well as some police reports that relate to the Karen Reed case that involve officers. They're also either in the Johnson or the King matter. And so we initially had talked about whether or not we would file Rule 17 motions for that information if the Commonwealth wasn't willing to give it to us. I think the Commonwealth has taken the position that if we can justify it under Rule 14, that they would give it to us at Rule 14. And I think, and you can correct me if I'm wrong, that if it wasn't Rule 14, that if we asked for it under Rule 17, that maybe the agency objects, but I don't believe the Commonwealth would object under those circumstances. I just want to make sure I'm clear about that.
All right.
We've been going back
This
and
is
forth.
not an issue in front of me. The only issue here is the issue of the federal materials and what's going to happen to the federal materials. So you can work out whatever you want with the attorney.
She's saying that she doesn't think the Commonwealth objects, and there's two different rules that they can use. And the issue is not necessarily the Commonwealth at this point. She's saying the issue is the feds, and they're trying to figure out how to work in a very unusual and difficult circumstance while providing representation for their clients, knowing there's this other world of discovery out there that's related to officers that are in connection with all of these cases. Her two defendants, Johnson and King, have, murder cases in Norfolk County that go through the Norfolk County DA's office and elsewhere, are investigated by the Norfolk branch of Massachusetts State Police and the troopers there. That was Proctor's division. So all of the troopers involved in the investigation of the Karen Reed case are involved in the investigation of all these other cases because that's their unit, and these are all homicide cases. This is the homicide unit for this area. So shock me that all the same officers are involved. So of course the defense is like, can we mention it all, please? So the defense attorneys are like, we are trying to deal with this very unusual and somewhat unprecedented circumstance. And there's this federal order that the Commonwealth has till tomorrow to have these materials and then has to give them back. And if the defense can't get them from the Commonwealth, getting them from the feds is going to be much more difficult. And these are defendants that are still pending trial.
Prosecuting Mr. King or
Well, my concern is I don't want to say I don't have any objections if I'm not going to be able to get the information from the Commonwealth. That's the whole point. The Commonwealth
What information are you talking about the federal materials or are you talking about other materials?
The materials that are listed as federal materials, which include state grand jury and police reports.
State grand jury is not federal materials. State grand jury is in possession of the DA's office.
Right. I made
And
that.
that's not being returned. So the question is federal materials. Is there an issue with respect to the return of the federal materials?
So those state grand jury minutes and the police reports are listed as federal materials, Judge.
What am I missing?
I don't think you had the opportunity to review the index.
The judge is frustrated, clearly, saying, well, state grand jury minutes aren't federal materials. And the defense is saying, well, they're listed in this index that we got of federal materials. So they're listed in the federal material index. And the court's like, excuse me, the fuck? Those are not federal materials. Why are we talking about these things? And do we have any issues with the fact that the DA's office has to return all these materials to the feds tomorrow? And so that's not on the defense. The prosecution is now stepping in, seemingly to also support what the defense is saying and say, well, Your Honor, you haven't had a chance to review the log of what is considered federal materials. So it's on there. Okay. Continuing on. I turned it up a bit more.
That's why you're less information than the parties do. So I think the best way to explain it would be that state grand jury minutes, which the Commonwealth produced in discovery to the defendant in Reed, also became.
You gotta be fucking joking me. You gotta be fucking joking me that they're also having lawn day outside the windows at the courthouse. Seriously. It's me. It's not me for once. That's in the background of the court. You got to be joking me. Good Lord.
Federal materials which were reproduced to us. So we have them independently, and if a defendant filed a Rule 14 for state grand jury minutes or for police reports in the Reed case, we would evaluate that because we have those materials in our possession, custody, and control.
Right. So
separate from the federal materials.
Right.
So I agree with the statement that Ms. Capiccio made about the state materials that we have complete control over.
Okay.
I appreciate that the Commonwealth, as the judge was already annoyed, the Commonwealth stood up and said, Your Honor, this is why it's an issue. It's listed here. It's part of the federal materials, but we also have it. So it's not something that has to go back to the feds because it's our materials that the feds have, but it's listed there, and the defense would normally not be entitled to the state grand jury proceedings in a different case. So this is a very unusual situation.
So I don't consider those federal materials. The federal materials are materials that only the feds have control over and that are exclusively covered by Judge Gasper's various orders.
Understood.
And the question is whether there's any obstacle to the return or destruction order, which has to happen by tomorrow. And I've got nothing from you in writing.
No.
Okay. Okay. Does anybody else want to be heard on the issue of destruction or return, other than Mr. Tipton, who's filed something? Okay. All right. So, fine. Mr. Tipton, do you want to be heard on the issue of return or destruction of the federal materials? can't really hear you, and I bet Attorney Beatty can't hear you, and I bet the defense attorneys can't hear you who are arrayed in court. So, sorry, Margaret. Mr. Tipton, can you do any better?
Mr. Tipton, I have a recommendation for a microphone, sir.
I'm going to allocate $10 of funds to buy you a microphone. This has been a persistent problem, Mr. Tipton.
Mr. Tipton, AirPods would work fine, sir. AirPods, do not try to use the microphone on your fucking laptop. Get headphones with a mic, just anything. And the judge is like, I will literally pitch in $10 so we don't have to fucking do this every single hearing on these issues.
CPCS can spring for it.
I've had to call on my cell phone and put it next to it.
All right, let's try that.
Rosemary's always the problem solver, right? Rosemary, the problem solver.
Yourself now, you'll be on video.
She's like, bro, I'm just going to call you on your phone. I'm going to put it by the mic. We're not fucking doing this. Stop it. Stop it.
I'll be able to see you, but we'll work on the audio connection via cell.
Which means Tipton's going to have to mute his mic on his computer and then be on his cell phone. For all of you in the chat saying, isn't this what happened last time? Yes.
Can you able to hear us? Yes, I can. Let's try that again. Can you identify yourself for the record?
All of the technology in the world, and courts are still like, excuse me? I can't hear you.
All right, is everybody able to hear that?
No.
Okay, very good. All right, Mr. Tipton, go ahead. I've read your motion. It is very bare bones.
Basically, what I'm saying, Judge, is what we've been trying to say for the last few weeks, is that if you allow the destruction of these documents that we have never been able to review in their entirety, we lose the opportunity to ever review them, and it certainly would prejudice the defendant, my client, in the event of an adverse verdict, for there being a public record to review with regards to what's ever contained in those documents. And without breaching the protective order, I can only say that, having reviewed what was provided now, pursuant to the protective order, I completely agree with the Commonwealth that what they produced was favorable to the defense, and it gives me reason to believe that other documents that are contained in what's called the federal documents may very well contain favorable evidence if it was reviewed by a defense counsel that's familiar with the facts and circumstances of the case.
Even closed captioning can't pick up Tipton because I really don't think that they ever put the phone on speaker, but I can't know that for sure. It's just so low, even with the microphone. Attorney Tipton is the attorney for Brian Walsh, and what he is saying is, Your Honor, I agree with the Commonwealth. The things that have been turned over from the federal materials is favorable to the defense, which gives me reason to believe that there may be other materials in the broader category of federal materials that are favorable to the defense. And if these materials are destroyed, if there is ever an appeal, these can never be reviewed because then only the feds will have them. And we have two different court systems, and you can't easily, as we are seeing, just go to the feds and come back with the materials. And that is the problem that they are dealing with right now is we have a federal order telling the Commonwealth that they cannot give these materials other than what they've been approved for to all these defense attorneys, and they have to return them or destroy them tomorrow. And Tipton is saying, but if you allow them to be destroyed, it prejudices the defense because we never have the opportunity to know if there are additional things that are favorable because we've never seen it. And the defense has to prove that what is in the materials they don't have is favorable to them. We've gone through this numerous times, which is like, oh my goodness. So let's continue.
That's what we're doing here. And so for the reasons I state briefly in the motion, that the Declaration of Rights has often been ruled to provide more protections in the context of defendants' rights in Massachusetts, I would ask on behalf of the Declaration of Rights, on behalf of Mr. Walsh, that the court order that the Commonwealth maintain a copy of all the documents they have, notwithstanding the order of his Honor Judge Casper.
So the defense, Tipton for Walsh, is saying, I want the court to order that the prosecution maintain a copy of all of the federal materials and to not adhere to the federal judge's order saying return or destroy them.
All right. Attorney Beatty, before I hear from you, Mr. Tipton, I have a essentially 3-page motion from you. It certainly says that you agree that documents produced to you are favorable to the defense. I didn't read it as saying that it gave you reason to believe that the Commonwealth had other materials that hadn't been produced, which were also favorable to the defense, or even that you might come to a different conclusion than the prosecutors came to with respect to the federal materials. And I don't have an affidavit from you, and I don't have any description of any of the materials, which could be provided to the court under a motion to impound. It could have been sealed, identifying a single document that would fall into that category of favorable to the defense but not produced. So I'm not quite sure how you expect me to grapple with this extraordinarily bare bones affidavit that's not supported with.
How many times has the court said bare bones? The court has essentially just said to counsel, hey, counsel, there were a whole bunch of ways you could go about this, and the way you went about this is not sufficient at all. It is a bare bones motion without an affidavit, and it's not even asking for the thing you're asking for, an oral argument. So what do you want me to do? It is procedurally improper. So how can I do what you're asking me to do when you didn't ask for it?
Bare bones motion that's not supported by an affidavit.
I swear he said bare bones motion at least 4 times. When the court has said bare bones motion that much, you're on the losing end of whatever is about to happen, because the court is like, no, this motion is insufficient.
I will, if the court will accept it, I'll file an affidavit by the close of today, and I'll file it under seal, and I'll lay out what my specific thoughts are based on the review of what's been provided.
Right now, I don't have enough, for sure, to issue an order contrary to Judge Casper's destruction order.
I'd ask that be done within 45 minutes, Your Honor. We have had this date for well over a week. There is an index, which I'm going to ask the court to.
Okay, we haven't had this hearing for well over a week. It's been like a week. But the prosecution is saying, Your Honor, if he's going to file more, we need an opportunity to respond. The deadline looms large. Literally, why couldn't this have been done yesterday?
Consider as you're making this decision that Mr. Tipton has, and certainly he could have filed a motion under seal that had more specific information in it, but we do not have time. The Commonwealth has continually been faulted for taking its time. But I would ask that be filed by 3 o'clock. I will wait, and then we can have further hearings on this today.
No. What?
Mr. Tipton,
Yes, Your Honor.
did you hear what Attorney Beatty was just just saying?
Yes, I did.
Okay. Can you file something today?
I certainly can.
Okay.
But I heard her say 3 o'clock,
What?
and I will do everything I can to get it filed by 3 o'clock.
We'll put this on for a second call.
This hearing started at 2 p.m. Eastern. She's like, file that affidavit by 3 p.m. Eastern, and we'll put this on second call, meaning we'll come back to it. Oh my God.
We'll put the Walsh matter on for a second call, and we'll go through our list, and whenever we can get back to this case, we'll get back to it. Whatever you file, make sure you email to Ms. Hamel.
Second call means
Judge, could I
they'll
just
call it again
address the
later.
board?
Okay, Mr. Crosby?
Sure. On behalf of Mr. De Los Santos, I appreciate that Mr. De Los Santos is not a co-defendant of Mr. Walsh, but certainly there's a consolidation of litigation. So I would prefer that my client too have a second call, because I would join any relief that the court grants to Mr. Tipton and his request.
There's been no consolidation of litigation. We've been having these hearings jointly because they involve a common issue. But I've got nothing from you suggesting that anything in the materials relating to your client is problematic or hasn't been produced from the federal materials.
Oh my God.
So you're welcome to...
The defense is like, we join in that motion. The court's like, the fuck you do. You don't join in that motion. It's not your client. You can't just be like, give me whatever you give to him. They're separate cases. They're not co-defendants. They're not the same case. They're not the same victim. They're not the same facts. Whatever Tipton does, give it to me too. Give it to me, Your Honor. No. How about no? You didn't file a motion. You don't get to just copy his homework. You have a different case and a different client. Stop it. Oh my God, the judge is like, no, that's not how it works.
Stick around, but I'm not going to hold either your client or Mr. Piccio's client here for a second call, and counsel is welcome to stick around if you want. Okay? We'll put this on for a second call.
No.
Mr. Walsh.
Judge, I did have two motions that don't have anything to do with Mr. Tipton.
And so I'll take them up in the ordinary course. Has your client been interviewed to determine indigency?
I don't believe so, Judge.
Okay, so your client needs to be interviewed, and that'll include information about what's been.
There are 5 cases that are being heard simultaneously at the moment. And so the Walsh matter is on for second call. The De Los Santos matter, the court's like, you can stay here, but I'm not going to do anything different. And we're back to the King case and the Johnson case.
Paid so far, things like that.
Yes, Your Honor. Can I approach sidebar on that?
Can you approach sidebar on it?
Yes.
No, we need to have an interview first, and then I'll take these under, I'll take them under consideration. Okay?
Can they be interviewed by probation today, Judge?
We've got a long list. I don't know if probation can or can't. Mr. Tipton, I'm giving the phone back to Mr. Piccio.
Do you want to leave one?
No.
All right, hang on.
Judge, I also, prior to, I know you're not going to give my client a second call, but there is a pressing matter I'd like to address at sidebar with the court and Commonwealth.
Okay?
If we could?
Yeah.
Okay.
And that white noise you hear is the sidebar noise over the jury box, which is covering the media. The prosecution and the defense are at sidebar. On the De Los Santos matter, we're going to zoom past that sidebar and the horribly grating white noise machine. And then we will see where we get to if they second call these cases, because this is a lot. All right. They turned the white noise machine back off. There we go.
We did not have the next date. Commonwealth, in the time that it filed, we went to report, Commonwealth filed 2 Rule 17 motions. We're asking that they be put on for argument for December 4th at 2 p.m. I know Mr. Piccio has a homicide trial starting in Suffolk County that she anticipates will go 3 weeks. We're asking for December 4th for argument on those Commonwealth Rule 17 motions.
That's fine.
Thank you. Thanks, Your Honor. No, this is only for Miles King. This is purely for Miles King.
Do we have next dates on the other cases? So let's just run through them. But we do now have a next date on Mr. De Los Santos. What about Mr. Chanchicho?
I don't believe so. I think Johnson and Chanchicho will need another date.
How long is it going to take for the second round of interviews?
We're hoping that we'll be able to produce that by the end of the week next week.
So would you put that as well on December 4th at 2? Would that be
Johnson and Gio?
Yes, sir.
If that's okay.
That's fine, I would just ask that Ms. Gio's presence be waived.
I think she should be here, okay? I will not waive her appearance, so.
Oh boy.
And two, I'll move some things around.
Judge, if I could, with respect to Mr. King, he can see probation, we're gonna have time with him, but Mr. Johnson, if he goes back and doesn't see probation, he won't be able to fill out a form until the next time he's which will be December 4th. And the
If
information.
we can get an interview today, we'll do
No, I'm
it.
not looking to put any additional burden on anyone, I'm just saying, to the extent that we could get it done today, I'd be looking for access to those funds so I can give the court an update on where we are in terms of looking at the personal phone.
Okay.
We'll see. I mean, we'll see if we.
Rosemary's defendants need to be interviewed by probation because it seems that wasn't done when they were released from custody, even though it should have been. So part of the issue is that needs to happen so that they can reappoint her as defense counsel. So some of this is just nuts and bolts foundational work. Now she is talking about getting information from Proctor's personal phone. So we have moved from what are the next dates, which cases are coming back when, which defendants need to be present in court, and then which defendants need to be interviewed again. And it sounds like both Johnson and King need to be interviewed by probation. And she is asking that be done before they leave court today so it can get done today if probation's available today. So these are just literally logistics. If you're like, I have no idea what's going on, it's logistics. It's logistics. Logistics is what's going on. So once we get past the logistics, Leonard, I am still saving your questions so we can get to those after court because I know there are many, but some of this is a very normal court hearing. There are 5 cases on, which makes it a little bit more chaotic than normal, but this is what day in and day out is like in court. What are we doing? When's the next date? What do we have? What do we not have? Who needs to be interviewed? What has been done? What hasn't been done? Why hasn't it been done? Okay, can it get done today? Because if it doesn't get done today, it might not get done between now and December, so it needs to get done. That's not uncommon. This is not uncommon.
Thank you, I appreciate that.
Thank you.
All the cases that were just on calendar, so it looks like Johnson is still in custody. And that's why she's like, can he get interviewed? Because if not, they're not going to interview him till they bring him back to court. And we're going to be in the same boat in a month. Yes, these are about Proctor's discovery. And so all of this is dealing with multiple different parts of Proctor discovery. Because Proctor was on all of these cases. Nina, they didn't say when they'll come back. They didn't say when they'll come back. And not all of them are coming back. Because they set December 4th as a return date for some of the defendants. The only case that's coming back today is the Walsh case. And that should be shortly. So, I'm going to see if they left the feed running. Did they leave the feed running? Because there's a second call. So they should be back on the record for second call. So the feed is still running. It's just paused. Nope. Lies. It just ended. Why did they just end the feed if they are still coming back for court? Give me 1 second. Let me see if they populated a second feed without YouTube like YouTubing at me. YouTube, calm down. Gosh. Today, anyone else having YouTube issues on your end, it's not just you. I don't see a second feed. Miguelina, will you keep an eye? Because they are supposed to be coming back into court because that was put on second call. I just worry that the media doesn't understand what second call means. And so if that's the case, I will try to hop onto the hearing and take notes about what happens. So let's give a summary of what happened. We'll see if they go live again for second call. Otherwise, we're going to have to wait till December, which is fantastic. So a summary of what happened today. Not much happened today in court other than new dates were set in some of the cases because the court feed cut before they finished dealing with the Walsh case, which was put on second call, meaning I will call this case again later. But I also understand that there was a lot happening in court and then all the in-person defense attorneys left and the DA left because they're coming back. And so I understand that there might be some confusion on the part of those sitting in the media saying, wait, aren't we done? No, court's not done for the Walsh case. It's done for the other cases today. But what happened today? So today they were in court on the Miles King case, the Johnson case, the Walsh case, and the other cases all together to deal with the federal discovery from the Karen Reed case. There is a return or destroy date for the Commonwealth tomorrow, October 31st. For those of you watching this later on replay, October 31st, 2025. That date is set by court order by the federal judge. That means that the Commonwealth of Massachusetts has to give the feds back the federal discovery from the Karen Reed case tomorrow or destroy it, but return it. The attorney for Brian Walsh said in his bare bones motion, as the court said 4 times, Your Honor, I am concerned. If this is destroyed down the road, we can't even review it to see if everything exculpatory was turned over. We have no way to access it. The defense will be prejudiced by it. And we are asking the court to issue an order that the Commonwealth maintain a copy of all of this federal discovery because the Commonwealth has turned over information to us that is beneficial to the defense. So in argument before the court, the attorney for Brian Walsh said, I believe that the information given to us indicates that there is other information out there that may also be beneficial to us. So exculpatory or potentially exculpatory information, but at minimum, beneficial to the defense. And the judge said, well, that's not in your written motion, and there's no affidavit. But the affidavit would have to be under seal because all the federal information is under seal, so the attorney can't say in open court, well, they gave us this, and specify those things and talk about what they said because it's still under seal. So what the defense attorney said is, I will file an affidavit with the court by the end of day. And the Commonwealth said, we need to respond to it. The end of day is too far. Can we do it by 3 p.m. so we can just address it today? And then we can have further hearing on it today. And the court said yes. And the defense said, I'll do my best. Types furiously. I'll do my best to get that in by 3 p.m. So the court said, I need more information because the state level court is in the position where the Commonwealth said there was exculpatory information or potentially exculpatory information that we need to give to the defense. And the federal court order said we can give these things, not those things, and those things have to be returned to the feds or destroyed tomorrow. So there is a federal court order that potentially conflicts with what needs to happen in the state prosecutions. And if you're sitting there going, I don't even understand how any of this is happening, this all sounds strange, right? Because the fact that there was a federal investigation going on at the same time there were state level prosecutions is an incredibly unusual circumstance. And Proctor had his hands in all of these cases because the homicide unit for Norfolk is fairly small, and these are all other Norfolk homicide cases. So it is the same set of troopers and former trooper that are involved. So of course the defense attorneys are like, excuse me, can we not destroy all of it? That seems like a problem. So the judge in court in the Commonwealth, Krupp, is saying, I need more information if you're asking me to file an order that orders the Commonwealth to essentially ignore the federal order. So we are having a whole battle over, well, which court's order is going to take supremacy from one to the other. And the defense attorneys are saying, yeah, I don't care about the feds. I need this information from my client. The feds are saying, we're not going to give it to you. This is not your case. So the fight over discovery for the federal discovery continues. The state level discovery won't be as difficult. Proctor's personal phone and all the other state level information. There will be some of a court order needed to give more Karen Reed materials to these defense attorneys. Generally, a defense attorney in like the Brian Walsh case is not going to get the grand jury proceedings from the Karen Reed case and probably still won't get all of them. But as to the troopers that are involved in both cases, the defense is making the argument, we need those materials because they are so interconnected to everything else. So, what happens from here? Well, we will see if we get to see the second call in the Brian Walsh case because that's not done for the day. And the other cases are going to be back in December. So December 4th, the other cases will be there. None of the other defense attorneys said that they object to the Commonwealth returning the materials tomorrow. None of them said that. The defense attorney for King and Johnson said, I just want to make sure that the items listed in the index from the federal materials, the state grand jury transcript, and the Commonwealth level police reports, I want to make sure that those things do not get returned. And the court said, those are in the possession of the Commonwealth. That's not a problem. And she said, okay, if that's not a problem, then that's fine. So Goosebump 801 said, why would the other defense attorneys not have an objection to the return or destruction? It might be because, well, there could be a ton of reasons, but it might be because the information in the Reed case doesn't really overlap with their case in the same way that it might in Walsh. So it just depends if what they saw applies to their cases specifically. They are all differently situated. And it might be that based on what they've been turned over so far, the other defense attorneys are like, oh, the stuff from the personal phone that goes back further is going to be more helpful. So we'll see. It also is going to deal with which troopers are involved and how. I don't know who the lead investigator is for each of these cases. It might be that in some of these cases, Proctor was lead and some of them he wasn't. And so it's not as intertwined. So all of the defendants are in a different circumstance. All of their cases are different. I mean, there's two that are co-defendants, but still. And so they are differently situated. Though we did see the defense attorney for De Los Santos saying, whatever Tipton wants to do, I want to do that. And the judge is like, oh my God. Custom Shadow said, I'd love to understand this a bit more. Shouldn't it be the same material? The federal material is the same, but the relevance and exculpatory nature of it could be different to each defendant because each defendant has a different case, a different investigation, and a different level of interconnectedness. The federal material is the federal material, but how it relates to each other case depends on those cases. Chicky said, are they all murder cases? Yes. Which is why they're all intertwined here, because it is the Massachusetts State Police troopers that do those murder investigations in this jurisdiction. And that's why this is so interconnected because it's all the same people. I'm going to answer a few more questions and then we will see where we're at. Because if I need to hop on and listen to the Zoom so I can tell you guys later or tell you in the app, I want to be able to do that. So let's answer some questions. I don't know if they're going to pick this hearing up again, but we're going to answer some questions and go from there. I understand it's confusing and it feels like a total cluster. It is and it isn't. There's a lot of moving pieces. And I get where the defense is frustrated. I get where the court is frustrated. S Cubed said, what makes the Walsh case more relevant? I don't know. It's Walsh's defense attorney's perception. Also, Walsh is supposed to go to trial next month. Walsh, I think, of all of these cases, to the best of my memory, Walsh is the homicide that occurred most recent in time. So the federal materials may cover the time frame of Walsh's investigation more squarely than some of the other cases. Also, each defense attorney gets to decide how it impacts their own case. So it is also how each defense attorney sees that material. So time might be a thing, but it's hard for me to say because all of those federal materials are sealed. So we don't know exactly what's in all of them. We have a rough idea of the things that came to light in the Karen Reed case, but we don't know what else there may be. And I also don't know if there is digital evidence in the Walsh case, which officer or trooper is the one who handled that. And were they also a witness in the federal case? Is that different than in the King case? And so there's a lot of potential overlap. And then there's areas where there might not be as much overlap. So it really, really, really just depends. And here we are. Lyndon in the chat said, to be fair, Judge Krupp said last hearing it was against his better judgment to have a hearing today. Yes, he was already like, oh my God. Oh my God. But I do want to see if there is going to be more hearing today, and I want to make sure that I don't miss that. So I get it. It is very frustrated. Richard said, this is what we rescheduled food court for. You never know what's going to happen in court. It could have been a day that was much wilder. It could not have been, but we voted and we did food court yesterday. I'm glad we did because we had plenty of time for food court yesterday. We would not have had as much time for food court today because I do have family stuff with the kiddos this afternoon. So Rocketus said, can't hear shit, Captain. Yeah, that's exactly how the beginning of this felt. Natalie said, how was Proctor's personal phone subpoenaed again? How did they know there was work stuff in the personal phone to unlock all of this? The federal materials, I think, linked all these together. That is my understanding. Some of the stuff we just don't know. Indigo said, happy Halloween, law nerds. Happy Halloween to everybody. Trisha said, what is the rush to destroy all things considered? There's a federal court order with a date on it. And that date's already been pushed a couple times. So it's the federal court order. That's why. Otherwise, this wouldn't be happening. The state or the Commonwealth normally wouldn't do this like this. But the feds said, we gave you this material for the Reed case. The Reed case is over. Give it back or get rid of it. Period. This is not for other cases. This is for this one case. The feds are like, no, there are also rules federally. You can't just. So, Ashley said, loving the skeleton earrings. I actually did find them on sale on Amazon. So I linked them in my Amazon link for you because on YouTube, they would only link them from a different location that had them for like $30 more. And I'm like, I'm not looking at that. So I have them linked in the Amazon shop. Forever Wander said Norfolk is Norfolking today. The court had so many things on calendar today. So even though we're not seeing what's going on in court, there are other matters going on in court. Let's see. David said throwing in 20 so we can not do this twice. I really need that attorney to just look, even an AirPod, like if you get a newer like AirPod, it will pick you up better on Zoom than whatever is happening. Do not use the microphone on your computer. It is not going to work. It's not going to work. Denise asked, why does anything get destroyed? I don't understand that. The federal court order. And destroyed is the alternative to giving it back. So give all the material back. But then again, if there's the destroyed would go to if there's files saved on your computer, you need to delete them. You need to return the digital copies to us, and you need to not still have a copy. So all of that. Music to My Soul said, do you think the judge is being somewhat inconsistent by saying the others can't join in Tipton's motion when he allowed the lawyer he denied to stand in multiple lawyers in the last hearing? I don't think so, because it's a different thing. Standing in for an attorney and saying, I'm representing this client, I'm setting new dates, I've talked to this attorney this work, is totally different than joining in motions on unrelated cases. So no, the judge is saying procedurally we are following the procedural rules here. And if you don't follow the procedural rules, I can't help you. So the judge is like, you've just got to, literally, you can't ask me to order the DA's office to essentially violate a federal court order without more than a bare bones motion. Like, you've got to give me more to justify this because it is going to be a fight. Let's see. Who is the attorney that looks like Lally? I don't know. It is hard for me to keep all the names straight because we have seen different couplings of these attorneys in court. It is difficult for me to keep their names straight. We only hear from some of them sometimes. They don't always announce their appearance before we hear from them. And we're not covering all of these cases. It's the discovery issue in these cases that has become quite a quagmire of jurisdictional battles between federal jurisdiction and then state level or Commonwealth level jurisdiction. It's a legally difficult and interesting problem. And I understand that just watching it feels like a total shit show. But also, I very much want to continue to follow the fallout of all of the Trooper Proctor stuff, because we're not even done with the fallout. There's no way we're done with the fallout. Nina said, do they even still need the federal material? They can get Proctor's whole phone extraction now from the state. Nina, I agree with you. And I would just offer, if I was the defense, I would want to make sure that what I had in the federal material matched what I had in the state material. And if the federal material also has the work phone and the state material doesn't, I would want all of that too. So if I'm the defense, if I know it's out there, I want it. Like, I want it all. I want it now. Give it to me. And I think that's appropriate for them given the things that have been unearthed. But also, after the defense now knows that they have the personal phone that goes back further in time, the defense attorneys who have cases that go back further in time might not be as concerned about the federal material. The Miles King case, let me pull up the indictment real quick, because I think the indictment goes back further, significantly further than the Walsh case and the Reed case. So some of it is just going to be how close or far in time these are. And let me see, it is not pulling up easily, but I believe it's a 2020 case, 2021 case. So for the cases that go back further in time, it might not be as relevant what's in the Fed materials, because the Fed materials aren't going to go beyond the death of John O'Keefe. They're going to start there and go forward. So if the investigation in the King case was happening a year before that, the Fed materials aren't going to cover that initial investigation. So that's going to be, I imagine, a part of the reason it's more relevant for some attorneys than others. So I'm going to keep answering questions. And then if I need to go jump on to Zoom, I will go jump onto the Zoom and listen, because there is a prohibition against sharing that. Don't understand why the judge doesn't take the stuff. Kathy, I don't either. It would be the cleanest solution, but the judge might not legally be able to. They might not have a procedural mechanism. The judge can't just do shit. There has to be a procedural mechanism. And it's easy for me to say, hey, vibes, I would love the court to do this. I can't tell you a code section that would allow the court to do that. I'm also not a Massachusetts lawyer, but a lawyer would have to go in and be like, hey, Your Honor, under code section this and case law of that, the law says you can do this. Can you please do it? I haven't heard any of the attorneys suggest that, which means it might not be possible in Massachusetts for the judge to do that. So the common sense solution and the legally available solution might not be the same thing. And the court can't just be like, well, vibes, this would make it all easier. There has to be a lawful way for him to do it. So David said, going back to the cell phone thing, they need an Anchor Bluetooth conference speaker. Works great. We'll literally mail a 5-pack to the court to prevent that. A, I love my Anchor products, and B, right? Just right? As Cube said, please send good vibes to my sister who starts a term as a judge in family court in Hawaii next week. Good vibes. Family court is hard. It is okay to take a minute when you need a minute. I think what I've seen from newer judges the most is that they feel that they have to sometimes do things on the spot. It's okay to take a minute. And we have seen that with some of the really good judges that we like. And we have seen that in Utah where the judge says, I'm going to take 20 minutes and I'm going to take a look at this. It is one thing that newer judges feel like, oh my God, I should just do it from the bench. It's okay to take a minute if you need a minute to review things. You don't have to do it while everyone's staring at you. But it's totally okay to make the lawyers do it while you are staring at them. That's totally fine. Okay. So I still don't see by President Trump. Nope, that's just like random live news. I don't see another feed for this hearing. So I think what I am going to do is go tune in to that hearing, because I can tune into that hearing. I just can't broadcast it. And then I can share in the app what happens, because they're going to end up setting another date for this on Walsh. And that's kind of where we're at. I know it is a shorter stream for us, but I want to know what happens in the Walsh case. We are going to get another date. And in getting another date for this, we might get an indication of when Walsh is going to trial. The prosecution has been pushing for it to go to trial in November. I don't think that can happen with all of this. I hope that we can, but I don't know if we can. Been there said, can they use this in the Karen Reed civil case? The federal stuff, no, but there might be a way that, well, it depends on who they sue next, but it will be harder for them to use the federal materials in the civil case than the state materials. But it is going to depend who they sue. They can ask for it. They can absolutely ask for it. So I'm sure, Jen, that Tipton met the 3 p.m. time to file, but the prosecution has to review it, and the court had a pretty full docket this afternoon, so there are other matters the court still has to go through. Yvetta, I am not going to cover it today because I want to hear the rest of this hearing. I will cover it. I'm just not going to cover it today. We simply do not have time. Also, it's not all that different than what I said the first time we saw that Cox hearing, which is, I don't believe this at all. So I am going to go pop into the Zoom so I can hear it. I am sure there will be others that will try to stream the Zoom. I follow the court rules on that. It says no streaming and distribution in the rules for access to those hearings. And everybody makes their own choices on those. I'm not going to judge anybody's choice. That's what the court says. So that's what I'm going to do. But it is what it is. And then I will update you in the Law & Nerd app what we learn from any additional 10 minutes. And if the cameras didn't leave the courtroom and pick back up, we will pick back up and I'll let you know in the Lawnard app at lawnardapp.com. If I do not see you today, I will let you know in the Lawnard app what happened. Lawnards, you are the best. I had so much fun with you yesterday in food court. I hope that you have a good, safe, fun, and scary Halloween tomorrow. Whether you are cuddling up in a blanket and watching spooky season movies, whether you are out trick-or-treating or somewhere in between all of it, I hope that you have an amazing time and that you get to enjoy all of the fall spooky season things. Honestly, this week it went from, oh, it's light out to, oh my God, why is it so dark at 5:30? Don't forget about the time change. I will see you next week. I can't believe next week's November. Lawnards, it is my goal to try to record a podcast with all the members in the background tomorrow. Fingers crossed. So we will see. So for those of you that are members, we will have some more for you tomorrow. Fingers crossed. That is the goal. Lawnards, it's so great to see you. It's great to spend the afternoon with you. Mods, it's good to see you. Thank you for being here. You guys are the best. I'm going to try to keep you informed on what's going on with court. So I'm going to go do that. I will see you soon. And I'll see you in the app. All right. Take care, you guys. I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Lawnard.